Good afternoon, everybody here in India, and good evening to our friends joining in from Singapore and in any other time zone. It's my pleasure to welcome you to this next SIAC India webinar. And today's topic is really party autonomy in the context of arbitrator appointments. We have a wonderful panel across jurisdictions to address these points and to have a lively discussion. I'm going to introduce the panel first, and then we'll start. My first panelist is Mr. Amit Sibil. Mr. Sibil is a senior counsel practicing before the Supreme Court of India and the Delhi High Court. Mr. Sibil has a rich experience in commercial law, practicing before these courts, and is also considered one of the leading counsel for arbitrations. He also has the experience of working in different parts of the world, including New York, as well as in Hong Kong. Mr. Sibil, I also understand, is an avid cricket fan, and so, you know, he brings that rich experience in the context of disputes as well. Mr. Sibil, welcome. Today he's joining us from London, so we truly do have a cross-jurisdictional panel. Thank you so much for joining us. Welcome again.
Thank you.
My next panelist is Kelvin Poon. Kelvin is a partner at Raja & Tan and is part of the International Arbitration, Construction and Projects practice. Kelvin is recognized as a dispute resolution star in Asia for construction and international arbitration. He also has been named as future leader in the 2019 edition of Who's Who Legal Litigation, and has been also described as an excellent strategist and is recommended by various legal directories. Kelvin, thank you so much for joining us today. Welcome.
Thanks, Purnima.
My next panelist is Elodie. Elodie is a partner with King & Spalding's Singapore office and a member of the firm's International Arbitration Group. Ms. Dulac has represented clients in commercial and investment arbitrations around the world, with a particular focus on Asia, where she's been here for more than 15 years. She also has worked with various international arbitrations under the rules of the ICC, ICSID, SEC, SIAC, and the UNCITRAL. She's also acts and sits as an arbitrator, so she would bring that rich experience to this panel. Thank you, Elodie, for joining us. Welcome.
Thank you.
Last but not the least is Anirudh Krishnan. Anirudh is based out of India. He also again sits and acts as an arbitrator. He has been recognized as a leading lawyer, has also authored a law of arbitration and conciliation published by LexisNexis, of which he's the chief editor and has contributed chapters in international publications as well. Anirudh has also worked at Clifford Chance in London as part of the International Arbitration Commercial Litigation Group. He is the founding partner now of AK Law Chambers, and his practice primarily includes commercial and public law litigation, arbitration, and corporate advisory. Welcome, Anirudh. We look forward to your discussions and contributions to this panel.
Thank you.
So if I may start first with Mr. Sibil. Mr. Sibil, I just wanted you to open this discussion with your thoughts on the concept of party autonomy and unilateral appointments with specific reference to India. I look forward to your thoughts. Thank you.
Thank you very much, Purnima, and thank you to SIAC for organizing this webinar on what is a burning issue in arbitration anywhere in the world. And the reason for that, of course, is that party autonomy in respect of arbitrator appointments in particular requires a balancing with the other cornerstone of arbitration, which is neutrality. Because of course, party autonomy is essential to arbitration in essence, as opposed to not being able to choose your judge. Parties can agree to choose an arbitration panel that decides disputes between them in advance by voluntary agreement. And that agreement should generally be respected. That's the principle of party autonomy. But what if they make a Faustian pact, for instance? What if they agree that one of the parties itself will arbitrate the dispute, or an employee of one of the parties, or a relative of one of the parties? To what extent are we willing to take the concept of party autonomy. And at some point, it hits the wall of neutrality, which is essential to any process of dispute resolution. And therefore, the issue in any jurisdiction where arbitration is practiced is how do you balance party autonomy against neutrality? The other reason you need to balance is that in many cases, party autonomy may be apparent but illusory, where actually the provision for selecting an arbitration panel is a take it or leave it provision that is not the product of real and genuine party autonomy. That's the second reason why we are concerned about preserving neutrality in the appointment of arbitrators. Now, with specific reference to India, the problem is nowhere more acute than in the concept of unilateral appointments of sole arbitrators. Now, sole arbitrators are present in a large number of appointment provisions in contracts in India, and in a large number of those, it is a unilateral appointment by one of the parties. And oftentimes, it is the case that where the government is a party to a contract or public sector organization, the provision in standard form contracts is for unilateral appointment by the government agency, which then doesn't give full confidence to people who look to enter into these contracts to actually go ahead with the transaction, facing a possible arbitration governed by someone appointed by the government agency, which of course inhibits investment and confidence in the arbitration process. And in light of that, the Law Commission in its 246 report lamented the sacrifice of neutrality at the altar of party autonomy and recommended amendments to the Arbitration Act, which were implemented in 2015. And in essence, what they set out is that there will be minimum standards for neutrality of arbitrators, which will render even arbitrators appointed unilaterally as sole arbitrators to be ineligible if they fall foul of those minimum standards set out in the 7th schedule, of course, drawn from the Iba Guidelines. But the problem I want to highlight is that as we see the amendments that emerged in 2015 from these recommendations, they clearly disqualify arbitrators and not appointing authorities. The consequence, of course, being that where you have an appointing authority that is one of the parties to the arbitration, then it can appoint an arbitrator, which though the arbitrator doesn't strictly fall foul, isn't an employee, but maybe a retired employee or in some other way related to that party that doesn't fall strictly foul. But because the party appointing has an interest in the outcome and decision in the arbitration, there is a lack of confidence in the process as a result of their unilateral appointment, which the amendments did not address. And these then came up in a number of decisions of the Supreme Court where this issue came to light. And some of those decisions in the ongoing discussion we will address. But I'll just touch upon one of them, which is TRF, very interesting case where the provision was that the managing director of the entity would be the arbitrator, failing which he would appoint his nominee to arbitrate on his behalf. That was the provision that was agreed to in so-called party autonomy. Now, the counterparty raised that this would render the arbitrator ineligible under Schedule 7 because he was a current employee of one of the parties to the arbitration. And the question really before the court was, if the MD was ineligible under the Arbitration Act, could he nominate then somebody to arbitrate on his behalf? Now, according to me, the ratio of what followed of the judgment, which held that he could not nominate someone to arbitrate on his behalf, is really that what one does through another is done by oneself. The court very much looked at it as not an appointment by the party, but an appointment by an arbitrator who was himself ineligible. and therefore directly falling foul of the Schedule 7 prohibition against current employees being arbitrators. Now, it's true that the decision contrasts this with a 3-member panel where each party appoints one and then they together appoint the presiding arbitrator. And some have interpreted this to mean that it stands for a larger principle that if the appointing authority falls foul of Schedule 7, it can't appoint a sole arbitrator unilaterally. But according to me, the contrast that Justice Mishra was drawing was between a party appointing a nominee arbitrator and a party appointing its own employee as the arbitrator who appoints his nominee. And it's in that context that the judgment is passed. I think TRF has been unfairly criticized as going beyond the Arbitration Act, and I believe it was squarely within the four corners of the Arbitration Act as it stood. But it left open the serious discomfiture with unilateral appointments where a party or an officer of a party was designated to appoint to arbitrate. And then that discomfiture was to play itself out in subsequent judgments of the Supreme Court, which I hope we'll cover in the rest of the discussion.
Thank you so much, Mr. Sibil. I think that succinctly sets the stage for the discussion today. Elodie, if I can take you now to talk about discussions in your experience. You've heard what Mr. Sibil said in the context of how the Indian courts are looking at it in light of amendments that were made. What is your view? Should there be any appointments made by parties at all, especially if party autonomy is as at the crux of international or domestic arbitrations, or should we be thinking of something else, particularly in the context of institutional arbitration?
Yes, thank you. So as you mentioned, like party autonomy is a key feature of arbitration. It's debatable whether it's a right of the parties or not, but it's a key feature. And when you look at surveys of in-house counsel of users, which have been made notably by Queen Mary, it's an essential feature in their eyes, the ability to participate in the process to select the co-arbitrator, possibly the chair. So whatever like the merits of that system is, it's for the users, it's still viewed as essential. And it's found in the most arbitration rules and the SIAC rules, there is a right for the parties to nominate their co-arbitrator. And they can really, subject to independence and impartiality, they can really nominate whoever they want. And that's their freedom. The only safeguards at that stage would be the statement of independence and impartiality by the selected arbitrator, and the fact most rules, including SIAC rules, would provide the parties nominate an arbitrator, but then that nomination has to be confirmed. The institution has to appoint the nominee. So there is its stage, which can be a safety net to screen the nominee, but I've never seen an institution like vetoing a candidate we put forward, but I mean, admittedly, we never put forward anyone we thought was biased or had like problematic disclosures. So that's for the co-arbitrators, but I think the users are also very, the default provision, for instance, the SIAC rules is for the chair. The appointment will be made by the institution, by the SIAC, unless the parties agree otherwise. But again, here, in most cases, the parties actually agree otherwise to keep a role even in the appointment of the chair. And again, it's whatever they're able to agree, but maybe the parties themselves nominate the chair, or it may be, which is more common, the co-arbitrators are going to nominate the chairs, but then each co-arbitrator will be able to discuss the candidates with the party appointing him. That has to be agreed with the parties because it will be an ex parte communication with a nominated arbitrator, but that's quite common for the parties to have a voice in who the chair is going to be. It can be also having a list procedure where the parties put forward names. But I think the message is like, even for the chair, the preference of the parties is to have some control, less than for co-arbitrators, obviously, but some control about who that person is going to be. And that's something also to keep in mind when drafting the arbitration agreement, because for the chair, most rules would say, like, unless the party agree otherwise, the institution or the ad hoc, like the default appointing authority would make the appointment. So something to include in the arbitration agreement if the parties wish to keep a role, not to leave it entirely to the institution. And I mean, I think it's a lot about perception, because I mean, leaving aside like the outlier cases where a party would try to appoint an arbitrator who's biased, but I think any reputable counsel wouldn't advise that, because it's I mean, it would be counterproductive anyway. The chair, I mean, the other co-arbitrator would see it. So leaving aside these like exceptional cases where the parties would make a questionable appointment, the issue is that the parties view this control, this participation as giving some credibility to the arbitration process and giving confidence to the parties in the legitimacy of the outcome. So I think that role is important in that respect, is the perception of the parties participating in the process when they have had that role in selecting the decision makers. Now, after the advantages can be more perceived than actual, because you may choose to appoint someone because the person has the expertise, you think, the person knows the country, like how business is done in that country, or often because lawyers know that person, they've appeared before him or her. Now, an arbitration institutions, I mean, a well-established arbitration institutions could probably make like an appointment, would make an appointment of someone competent. So it's more the perception of the parties, and it's not that the institution couldn't do it, which is what the proponents, I mean, the few proponents of giving up party appointment altogether have advanced, is that the institutions could make equally good appointments. And the criticism is that when you look at dissenting opinions, and I'm talking here about commercial arbitration, investment treaty arbitration is, there are more issues because of the issue conflict and the repeat appointments, and the decisions are public. So this is a sensitive area for that topic. But even in commercial arbitrations, dissenting opinions are like 95% statistics I've found, like written by the co-arbitrator of the losing party. Now, does that like frustrate the whole system of party appointment? I would say no, because in the end, the competent, first, they are not, from what I've seen in commercial arbitration, dissenting opinions are usually quite rare. And this is not necessarily a sign of bias or a sign that the system altogether has to be reformed. I think from what I've seen, yes, sometimes you have co-arbitrators who tend to ask like questions more helpful to the party appointing them than the other party at the hearing, but the other one may do the same. And in the end, these are like reputable professionals, and they will decide the case objectively. And I don't think there has been in commercial arbitration the same criticism, the same call for the reform of the appointment system as in investment treaty arbitration.
Thank you, Elodie. I think there were some very, very interesting and maybe even controversial points that were made to whether we should do away completely with party appointment, but at the same time you discussed, perception and the control that parties would want to feel that they have in appointing the arbitrator. Which takes me to you, Anirudh. From what Elodie has said, I want to ask you specifically in the Indian context. We've seen a number of recent judgments right up to the Supreme Court discussing panels of arbitrators. Could you start discussing some of the issues that in terms of party autonomy, especially if these have been signed in and drafted earlier into the contract as accepting? And we would like to hear your thoughts on that.
Yes. Thank you, Purnima, and thank you to SIAC for inviting me to be part of this panel. Insofar as panel appointments are concerned, there was a decision of a division bench of the Supreme Court in West Alpine's case, where the Supreme Court took the view that so long as selection was from a broad-based panel, in that case there were 30 odd arbitrators in the panel, such a clause would be valid. The Supreme Court went on to expressly state that in fact a panel needs to be a broad-based panel, otherwise it may not be permissible to have party autonomy restricted to a small panel unilaterally appointed by the other party. Following this, there were a number of other judgments. Mr. Sibil has helpfully gone into the ratio of TRF. TRF was followed up with a judgment in Perkins, where a division bench went on to hold that a unilateral appointment of an arbitrator is not permissible. The issue that then arose is that if the unilateral appointment of an arbitrator is not permissible, what about a unilaterally appointed panel of 4 arbitrators from which the other party had to choose its nominee? Would this fall foul of the rule in Perkins and TRF? A 3-judge bench of the Supreme Court in CORE case, Central Organization for Railway Electrification, after considering Perkins and TRF, went on to hold that the ratio of these 2 judgments would not impact a unilateral selection of a panel by one of the parties. The rationale that was provided by the Supreme Court in CORE was that the right of one party to unilaterally suggest a panel is counterbalanced by the right of the other party to choose from within the panel. Therefore, the ratio was that it is perfectly permissible for the unilateral selection of a panel by one party, even though in the facts of the case, the panel was not a broad-based panel. Following these judgments, there have been a number of judgments of various high courts. For instance, you have the Delhi High Court in City Cable, you have the Bombay High Court in ITD Cements, you have the Madras High Court in JV Engineering, all of which have considered Perkins, all of which have considered TRF and CORE. And the proposition that emerges today is that if the panel is a unilaterally appointed panel of arbitrators, so long as the arbitrators falling within the panel do not fall foul of the 7 schedule criteria, such a selection is valid. But, and specifically in the context of railways contracts, because in the railways contracts, there are 2 clauses. There is one clause that came to be interpreted in CORE. There is another clause that is a pre-CORE railway clause that provides for present employees. So interpreting the latter of the clauses, the Supreme Court went on to hold that CORE would not apply, even though when you read CORE, there are some paragraphs in CORE that seem to suggest that it would apply in a wider context. There are a number of High Court judgments, both the Delhi High Court and the Madras High Court, that have taken the view that that CORE must be restricted to the specific clause that was applicable in CORE, and that if any of the arbitrators in the panel fall foul of the 7th schedule, then CORE would not be applicable. So that's the position that emerges today. There is also a contradiction today between the judgment in CORE and West Alpine, which we can possibly go into during the course of the discussion today.
Thank you, Anirudh. Kelvin, I come to you now. You've heard Anirudh sort of succinctly try and summarize in his brief 5 minutes, all the decisions of the High Courts and the Supreme Court on the issue of a judicial panel and picking and choosing. If you could just talk to us a little bit about the IBA guidelines, which have been at the back of all of these discussions, and in the context of the IBA guidelines and conflict of interest for appointment, and pick up some of the issues that have been talked about here, particularly the red list, if you could touch upon that. Thank you.
Sure. Thanks, Purnima. The IBA guidelines really came about really in response to the increased complexity of business generally. I mean, we now see larger business groups, international law firms, international parties with very wide-ranging connections. As a result, therefore, there is a need now to see what these connections are to make sure that there is a proper disclosure of the interests between the party appointed as the arbitrator and anybody who might have an interest in the outcome in the arbitration. But one of the upshot of the fact of this greater need for disclosure is that with greater challenges and greater disclosure comes greater challenges, because the more information you give, the more likely someone's going to pick a bone and say that's problematic and raise a challenge. And so it is to meet this balance between ensuring legitimacy and the integrity of the panel, while also ensuring that we ensure arbitrations are efficient and not unnecessarily bogged down by challenges, that the IBA rules were brought about in 2004 and revised in 2014. And IBA guidelines truly now deserve its place as being one of the best known sources of law on this topic of independence and impartiality. Even though the IBA guidelines doesn't have the force of law generally, not like the way we have in India, which has adopted many aspects of the guidelines as hard law, the IBA guidelines operate as soft law, but it's a soft law of a very firm and established nature. I mean, we have seen many surveys, be it Queen Mary or the like, that have confirmed the broad-ranging acceptance of the IBA guidelines. But more relevantly, you will see in many court applications or many challenge decisions of the various institutions, you will find that the IBA guidelines are referred to and used as setting the benchmarks in deciding this question. So clearly, despite its soft law role, I don't think it's lost any of its forensic and normative force in guiding and developing the discussion of what it means to have impartiality and independence for arbitrators. Turning quickly to just what the IBA guidelines are about, there are two real broad portions in it. There's a general standards at the start, and then there's a list of practical applications of those standards by way of a traffic light system of red, orange, and green. The point simply is that if there is some fact or circumstance that's arisen since the appointment, which from the viewpoint of a reasonable third party, having knowledge of the relevant facts and circumstances that will give rise to justifiable doubts as to the arbitrator's impartiality or independence, that is a matter which will mean that the arbitrator should decline the appointment or refuse to continue to act. These principles, I think, are drawn together from many different sorts of case laws and statutes across many jurisdictions. And now it forms the baseline on which we all work and operate. But I think what's important to note is this: the use of the words impartiality and independence. These are words drawn from the model law, which has widespread acceptance in many jurisdictions. What's important to note also is that impartiality refers to a more abstract and subjective state of mind of the arbitrator, whereas independence refers to the more objective aspects in deciding whether there has been some circumstance that may suggest some compromise of impartiality. I think it's important to highlight this because in the end, when we're looking at independence, we're actually asking the question of whether the arbitrator is impartial or not, based on objective facts, looking at the links between the arbitrator and the parties to the counsel in question. And hence, when we see how the rules are used or deployed in real life, that is a key question. Throughout the IBA guidelines, there are constant references to how you need to maintain a fact-sensitive approach to these questions, and you cannot afford to be too prescriptive. So just one very quick example before my 5 minutes are up. In the rate list, there is a situation that says that the arbitrator or his or her firm regularly advises the party or an affiliate of the party, and the firm derives significant financial income therefrom. So the arbitrator himself is not the one advising the client, but the firm to which the arbitrator belongs derives that financial income. Under the IBA guidelines, if you read it literally, that is something that's non-waivable because it means that the arbitrator is regarded in that situation to be subject to a circumstance that will give rise to justifiable doubts as to his impartiality or independence. But in the case called W and M Sundaram Berhad in 2011, the English High Court reached a contrary conclusion. And the approach of the English court is interesting, because what the English court said is this: even though the firm earned substantial income from the affiliate of the party, the fact of the matter is that it is not the party itself. That's the first point. Second, the arbitrator himself did not advise the affiliate and operated only as a sole practitioner within the firm, sharing secretarial support. So he wasn't aware of the circumstance of the fact that the firm was earning significant income and did not make the disclosure. But given those facts, notwithstanding what the IBA rule guidelines say, the court found that there was no reason to assume or to see how the arbitrator could be said to be not impartial or being unable to be impartial in the discharge of his function as an arbitrator. And I suppose that sort of highlights or illustrates the sort of fact-sensitive approach that we ought to take. And it remains to be seen whether India, in its application of the 7th and 5th schedule, will also likewise adopt a fact-sensitive approach to the application of those standards.
Thank you very much, Kelvin, especially for contrasting the Indian position with the various positions in England, as well as setting the tone for the IBA guidelines as part of the discussion. Mr. Sibil, if I may come to you now. You've heard Kelvin talk about the IBA guidelines and the fact-sensitive approach. And this issue has been litigated many times in India in terms of party autonomy, as well as the need to appoint arbitrators and the perceptions around impartiality and neutrality. Could you please continue your earlier discussions and see how the Indian position is contrasting to either the English position that Kelvin spoke about, or generally the influence of IBA guidelines in the Indian context? Particularly, you refer to TRF and also in the context of Perkins, which is the more recent Supreme Court judgment. Thank you.
Yeah, thank you, Purnima. As Kevin started by saying, India perhaps is the only jurisdiction where the IBA guidelines are enacted as hard law in Schedule 7 and under Section 12(5) of the Arbitration Act. An arbitrator that falls foul of Schedule 7 is rendered ineligible. One of the reasons why it's probably been made hard law is that the issue of neutrality in arbitrators was an acute one that the Law Commission wanted to address, and possibly also because it wanted to reduce unending litigation, which might emerge if we take a very fact-sensitive and soft law approach to the issue, though I understand why that's a good approach in some other jurisdictions. But in India, I think they have deliberately taken the approach of enacting as hard law, and the idea is to reduce litigation in relation to the appointment of arbitrators. How much success have we had in that? Unfortunately, not much. And I will discuss a couple of cases just to illustrate why that is. So, as I said, TRF left open huge discomfiture on factual scenarios that didn't arise strictly in TRF, but were rampant, where you had unilateral appointment of a sole arbitrator by the party itself, or by designating an officer employee of the party to appoint the sole arbitrator when a dispute arose. This was the issue that arose in Perkins, and the Perkins court decided the issue by holding that sole arbitrators cannot be appointed unilaterally by a party. And the reasoning was that if the arbitrator has to comply with the guidelines in Schedule 7, then why not the appointing party? In other words, the test was, if the appointing party for a sole arbitrator falls foul of the criteria of Schedule 7, then it is likely to have the same bias as an arbitrator would have had if it fell foul of those Schedule 7 criteria, and therefore the same principle must outlaw an appointment by an appointing authority that is a party or an employee of the party or any of the other criteria in Schedule 7. However, A contrast was drawn in Perkins with 3-member panels where each party appoints one arbitrator and then the 2 arbitrators appoint a presiding arbitrator. And it was said that in that case, the appointing authority may appoint the arbitrator because it is counterbalanced by the counterparty appointing its own arbitrator. And therefore, the same concerns don't arise. I want to make 3 points on this. Number one, that this was by and large, the judgment was positive because it was a shot in the arm for independence and impartiality in arbitrations in India. Second, while it was framed as an application of TRF, it really, according to me, expands the principle in TRF perhaps beyond the statute mandates. Because very clearly the statute, the Arbitration Act, mandates restrictions on arbitrators and not on appointing authorities of arbitrators. And Perkins ended up holding that where a sole arbitrator is appointed unilaterally, then the same criteria will apply to the appointing authority because there's a likelihood of bias. The third point I want to make is that there is a huge gap between a sole arbitrator and a 3-member panel where each party appoints one and then they appoint a third. And in that gulf lies the potential of litigation, because the Perkins judgment appeared to allow courts to enter into a discussion of a subjective discussion of how independent and impartial the arbitral tribunal that emerges from a particular arbitration clause would be, where it fell between a 3-member tribunal with each appointing one and a sole arbitrator unilaterally appointed. Perkins and TRF together read outlawed unilateral appointment of sole arbitrators. You read them together, they enable and they preserve ad hoc arbitration where you have a 3-member panel, each appointing one. But what happens in between, where you have all these provisions providing for panels, where panels are set up unilaterally by one of the parties, usually a government entity, in infrastructure contracts? It simply sends, as happened in core, a set of 4 members of that panel. It may be that the 4 members don't fall foul of the Schedule 7 criteria, but it sets up the panel. The 4 members are retired employees, possibly of itself or other similar organizations. It is perceived that they have an incentive to hold in favor of the government entity if they want to have future appointments, if they want to be in future panels, if they want to have a role in future arbitrations. And the counterparty is simply told, please select a minimum of 2 out of these, send them back to us. We will, on your behalf, appoint one, and then we will appoint the other 2 from this panel or from outside this panel. Now, in the core judgment, the Supreme Court was faced with a situation that if you hold that courts will evaluate such a clause to see how neutral the arbitral tribunal would be, it would lead to grave uncertainty, delays in arbitration, and so on. The Supreme Court ends up saying that TRF will not apply to such a situation because it is restricted to unilateral appointment of sole arbitrators. And in any case where there is any involvement of the other party in appointment of the arbitral tribunal, TRF will not apply, is what emerges from the core judgment. And it's as a result of that Anirudh tells us that various high courts subsequently have also held that as long as there is some involvement of the counterparty in the appointment of the arbitral tribunal, the court will not interfere and will enforce the so-called party autonomy. But the question remains, is it really party autonomy in such infrastructure, take it or leave it standard form contracts? 1. 2, is it really a counterbalancing to say that a party will pick at least 2 out of 4 and then the other party will appoint whichever one of the 2 that it sees fit, and then another 2 from that panel or outside, and similar other clauses? Is it fair to say that any involvement, however minimal, of the counterparty in the appointment of a multi-member tribunal is enough of a counterbalancing. It's a matter for consideration whether this actually addresses the serious concerns that the Law Commission expressed in its 246 report, and I just want to read one passage from it. The concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution of disputes. In fact, when the party appointing an adjudicator is the state, the duty to appoint an impartial and independent adjudicator is that much more onerous, and the right to natural justice cannot be said to have been waived only on the basis of a prior agreement between the parties at the time of the contract and before arising of the disputes. So I think CORE was on the right track in terms of certainty and the rule of law. I think it implements the mandate of the Arbitration Act as amended, but the problems remain in the area as between unilateral appointment of sole arbitrators, which is now outlawed and will hopefully be replaced by a system of more institutional appointments of sole arbitrators, and on the other hand, the three-member panels appointed. I may add, though, that as far as domestic arbitrations by three-member panels in India are concerned, some of the passages in some of the Supreme Court judgments appear to send a wrong message, that it is enough of a counterbalancing if party A appoints one arbitrator and party B appoints the other. It almost seems like a message to the arbitrators that as long as there is this so-called counterbalancing, they can unabashedly espouse the case of the party nominating them, which is certainly not what is intended in any regime of arbitration, but is happening, I'm afraid, in a number of arbitrations.
Thank you, Mr. Sibil. I think you've raised a number of very serious concerns about the judgments and how the law is evolving in India, particularly the issue of the authority that's appointing the arbitrators as well. Elodie, you've talked about in your earlier discussion the reference to do away with such unilateral appointments and put that burden on the institutions. I was wondering if you could please also come back to us in response to some of the points that Mr. Sibil has made in your context with your interactions with institutional arbitrations, as well as some cases that have evolved in France, which you wanted to highlight and see if they follow the same pattern as the Indian cases. Thank you.
Yes, thank you. The cases, I thought I would mention a couple of cases from France, because France is generally viewed as a very liberal pro-arbitration jurisdiction. So to see how have cases where set-aside action have been brought in relation for alleged lack of independence and impartiality of arbitrators, how is that, has it been handled? And which Kelvin had described some English case law, which was quite liberal. So first, there is actually a very recent April 2020 case by the Paris Court of Appeal, which now has an international chamber. And it was about LCIA arbitrations, LCIA awards between Brazilian companies, 5 awards. And one of the grounds for challenge was a lack of independence and impartiality of one of the co-arbitrators. So the situation was that this co-arbitrator had worked within the past 3 years, but was no longer. He had worked for a law firm, which was in turn affiliated to a Canadian law firm, which had done work, acted for the majority shareholders of one of the parties. So that was a relationship. The arbitrator hadn't disclosed this when he was appointed. He hadn't put either when he included his CV when he accepted his appointment, his work, the 2-3 years he worked for that affiliated law firm weren't mentioned. And then one of the parties quite fortuitously discovered the relationship, quite indirect at a later stage, and used it as a ground for challenge, to set aside the award. So the Court of Appeal, it wasn't with reference to the Iba Guidelines, but in the spirit and based on the French Code of Civil Procedure, which also requires independence and impartiality, and this is assessed on an objective basis. So the Court of Appeal reinforced like the continuous duty to disclose on the part of the arbitrator. But it also stressed that the lack of disclosure in itself is not an element to conclude there is a lack of independence of impartiality. You have to look at the elements which were not disclosed, the facts not disclosed. Do these facts amount to give rise to justifiable doubts as to the arbitrator independence and impartiality on an objective basis? And interestingly, the Court of Appeal, the arbitrator said he wasn't aware of the relationship, and the Court of Appeal was kept doubtful. They didn't say like he knew about it, but they were like they thought it was doubtful whether he actually wasn't aware of it. But still, having non-disclosure, the arbitrator inferring the arbitrators basically knew about what he hadn't disclosed and had to disclose. The court focused on required basically a business flow between the arbitrator himself and the majority shareholders of one of the parties. And it looked like, and it found like the arbitrator had never advised that these majority shareholders, he had never represented them. And on that basis, that lack of direct relationship, direct business relationship between the arbitrator himself and the shareholders of the party, the court found there wasn't a lack of independence and impartiality. And it rejected the action to set aside. So that was, I mean, if we look at the IBA guidelines, that was quite a liberal, because it looked at the arbitrator rather than his law firm and requiring a relationship between the arbitrator himself and not only his law firm and the shareholders of one party. And there is also a second case, a French case, which is a bit older, from like 10 years ago, but it's kind of a seminal case, one of the rare cases in France where there was an award set aside for lack of independence and impartiality of an arbitrator. And in that case, the court, the issue was that it was a well-known lawyer working for an international law firm who was the chairman of the tribunal. And he didn't disclose that his law firm had acted for the parent company of one of the parties and a subsidiary as well of that same party. And he didn't disclose it. The Court of Appeal set aside the award on that basis, finding it gives rise to justifiable doubts as to independence and impartiality. The Court of Cassation, which is the highest court on these matters in France, actually overturned the Court of Appeal decision, but on a procedural point, it found that the party which was alleging lack of independence and impartiality to set aside hadn't raised the challenge in the arbitration within the time limit under the ICC rules in that case, after it became aware of the facts. So it couldn't raise it in the action to set aside. And so the action to set aside was the Court of Appeal decision setting aside the award was overturned on that basis. So basically the takeaway is here, like that's the facts where there was really a strong relationship, like quite between the arbitrator law firms and several entities connected to one of the parties, which hadn't been disclosed. But the party shouldn't basically wait until to see how the award is going to go, keep the challenge on the side, and then if actually it loses, you bring up that fight in these facts in the set-aside proceeding. If there is a ground which is found, like which one party thinks gives right to justifiable doubts, they have to be raised within the time limit of 30 days under the applicable arbitration rules. Otherwise, a court may construe it as a waiver of the right to apply for set-aside on that basis. So that was just like a glimpse at what French courts, which are liberal, I mean, they obviously issues of lack of independence and impartiality are taken very seriously and can lead on their own to setting aside the award.
Thank you, Elodie. Anirudh, I was wondering if you could please come on next to discuss, some of the points that were brought up in terms of the 5th and the 7th schedule, and have they really worked in the Indian context, and your thoughts on any future amendments. Mrs. Sibil referred to the Law Commission report, and in that context, I know we've discussed a lot in the Indian context about whether we've missed the bus in terms of the amendments that have been made to the Arbitration Act. Your thoughts on these two issues? Thank you.
Thank you. I certainly believe that the 2015 amendments have had a huge impact, because when you look at the regime prior to that, you had judgments like Indian Oil versus Raja Transport, where the Supreme Court had taken the view that an employee of one of the parties could act as an arbitrator and there would be no presumption of bias. So the litigation in the pre-2015 era was on trying to carve out exceptions from Indian Oil versus Raja Transport, and you would see a number of judgments like Denel and Vipramas where some exceptions were carved out. That's the reason why in 2015, in fact, prior to that, as part of the Law Commission, there was an extensive discussion as to what are the nature of amendments that need to be brought in to legislatively overrule these judgments, Indian Oil versus Raja Transport and others. It was then agreed that instead of experimenting with a new guideline, we might as well accept an internationally accepted guideline. And that's the reason why the 5th and 7th schedules were incorporated, essentially bringing in the IBA guidelines on neutrality. Subsequently, there have been judgments, there has been litigation, but I think by and large, the system is improved. But ultimately, for any country to emerge as a very good seat for arbitration, the regime needs to be blemishless. We need to learn from the mistakes of the past 2 to 3 years and keep coming up with frequent amendments so that over a period of time, the regime improves. Now, post 2015, we have discussed some of the issues that have come up. Mr. Sibil was referring to some of the problems arising from Perkins and Core. I think in light of this, we certainly need a few more legislative amendments. Firstly, there is as I was mentioning earlier, there's a direct contradiction between the observations of the division bench in West Alpine and the observations of the 3-judge bench of the Supreme Court in Core, where in West Alpine, there is an observation that in case of an appointment of a panel by one party, the panel has to be broad-based. That has been, without consideration, implicitly narrowed down in Core, where even a panel of 4 was held to be valid. 4 ex-railway officers was held to be valid in relation to a dispute involving the railways. We need to, the first amendment that I propose is to bring back the law laid down in West Alpine in relation to a broad-based panel. Something like the National Highways Authority has a broad-based panel. There may be comments made on, say, individual arbitrators in the panel, but broadly there are 30-35 people in the panel. So the first amendment that I would propose is to bring in the broad-based panel rule as set out in West Alpine. The second is to consider widening the scope of the 7th schedule. The reason I suggest this is that ex-employees of a party have been held to fall beyond the ambit of the 7th schedule. There are observations in West Alpine to this effect. Now, if you are to strictly construe the provisions of the 7th schedule, this interpretation is correct. But I would believe that given the object behind the 7th schedule, the 7th schedule should not be restrictively construed, but should be liberally construed. Considering the fact that the same has been narrowly construed, perhaps there's a requirement to widen the 7th schedule, specifically in the Indian context. That's the second amendment that I would propose. The third amendment is maybe a little more controversial. So today, if there is a contravention of the 5th schedule, the remedy of a party is to raise it as an objection under section 13 before the arbitral tribunal. And if the arbitral tribunal holds that there is no bias, then the only remedy is for the party to go ahead with the arbitration and then raise it as a challenge under section 34, which means that you're forcing the party to go ahead in an arbitration before a panel that may fall foul of the 5th schedule. Perhaps a narrow window of an appeal against a rejection of an application under section 13 needs to be provided, where it can be clearly established that one of the parties fall foul of the 5th schedule. This is something that needs to be considered. I know this is controversial because you could also have a situation where in every case a challenge is raised under 13. That is the reason why I'm saying, instead of making it a blanket appeal against the rejection of section 13 order, make it an appeal restricted to cases where there's a contravention of the 5th schedule. These are 3 amendments that I can suggest. The third, of course, requires a lot more debate, because you don't want frequent appeals to be filed that would derail the entire arbitration process. But maybe I think every 2 to 3 years, we need to revisit the regime and see how we can learn from the mistakes of the past 2 to 3 years. And that's the way we will evolve as a good seat for arbitration. On a lot of other aspects, we have greatly progressed post 2015, but this is one area where I think a few more amendments are needed. Thank you.
Thank you, Anirudh, for those detailed comments. I think just a housekeeping announcement is that if you have any questions, please feel free to type it in to the question answer spot below, and we will try and get them answered in the short time that we have. Kelvin, I will come back to you now, and as you've sort of started the discussion on IBA guidelines, there's much that has been said both in the Indian context as well as in the French context that LOD also discussed. So I just wanted you to expand on that, and I see a couple of questions also coming in the Indian context of the schedules to the Indian Arbitration Act. If you could go down your traffic light signal analogy and talk about the others, so that we could relook at the fact-specific issues that you brought up. Thank you.
Thanks, Purnima. I think for the next 3 minutes, what I would like to do is to cover perhaps just 3 points. The first concerning issue conflicts. The second concerning repeat appointments. I think there's a question asked about that. And the third is this question about what sort of connections would be deemed unsuitable between the arbitrator and the experts engaged by the parties. So coming first to the question of issue conflicts, I think this problem normally arises because the client, quite naturally, when engaging an arbitrator, would want someone who is sympathetic to the position that they want to advance. And in the Indian context, where it is still fairly common for parties to seek to appoint a former High Court judge or former Supreme Court judge, it is not difficult to pass the judgments made by those former judges to see what are their views on certain points of Indian law that may favor the client's case. So a question that may arise is this: to what extent would the fact that the judge in question have ruled on a legal issue, would that amount to an issue conflict? Because if the same issue is going to be raised in the arbitration, could it be alleged that by reason of the decisions made by the judge previously, he will be unsuitable to serve as an arbitrator in the reference? And I think fortunately for us, there has been quite a good number of decisions that have been made in the context of investment treaty arbitration. One very recently on 8th July in the case of Vattenfall in Germany. In that case, one of the arbitrators had issued an opinion in a prior arbitration involving different parties concerning the Energy Charter Treaty. But the opinion that he had issued touched on an article that was directly relevant in the present underlying arbitration. And the question was, having made that ruling, was it discussed among the tribunal what the ruling was? Because that ruling was not disclosed to all the parties to the arbitration. And the arbitrator in question refused to answer whether they discussed his ruling previously in the deliberations, pleading that those deliberations were confidential. So in deciding whether there was a situation of issue conflict, the ad hoc committee held that in international arbitral proceedings, an issue conflict denotes a situation in which an arbitrator is inappropriately predisposed to favor a particular outcome with respect to the issues at stake. So it cannot be just, it's squarely linked to the facts and the problems in question and not just a general statement of law. So I think if that is the position that will be followed in India, then I think that should be a fairly safe ground on which we can continue to appoint judges or arbitrators who may have expressed views that are perhaps sympathetic to the cause of our clients. That's on issue conflict. Second, on repeat appointments, typically if you have an arbitrator that has been working with the law firm or the counsel on many occasions, it's quite natural that you'll go back to the same arbitrator. It is not because you might think the arbitrator is biased in your favor. It's simply because it could be that the arbitrator in question is efficient, integrous, and has expertise in the area in question of the dispute. So in that context, is there a problem with making repeat appointments? It could pose a problem in certain scenarios where, for example, the industry is very narrow and there are very few arbitrators with a specific expertise. And I think one important point to note is that while paragraph 3.1.3 of the IBA guidelines denotes repeat appointments as an orange list item, which means you have to disclose it, there is a footnote 5 to the guidelines that says that there is no need to disclose in certain limited fields where it is custom and practice for parties to draw on a small pool of arbitrators. So I saw the question posed in the question about whether this should be extended to the Indian domestic context. And so I don't have a direct answer to the question. I think the question to be asked is, are the pools in question so narrow that you have problems drawing arbitral expertise from outside what's your usual comfort zone? Because if there isn't that issue, then I can see why that could pose problems. And it's a matter of perception, at least, to a third party looking at the repeat appointments by one party of that arbitrator. And perhaps just to wrap up, I know my time is running up. And perhaps one example of why I think the making of the IBA guidelines hard law in India has proved useful for at least one of my clients is that we had a situation where one arbitrator in question had been appointed repeatedly by my respondent in multiple references in relation to a similar contract across all the different arbitrations. We were able to persuade the arbitrator to recuse himself because I think of the passage of the Act. The Act now makes it clear it's not just a guideline or a soft law, it is the law in India. And the fact that he did not disclose the prior engagements gave us ample reason to tell him, I think you're in trouble and you should consider withdrawing, and he did. And I suppose that is an illustration of why perhaps in the Indian context, having it as hard law would give the arbitration practice here as a whole a boost, because it could ferret out some of these practices, which might be harder to address if you're going to address these issues only as a matter of soft law or international practice. But of course, to ensure that this practice does not end up being a straitjacket for arbitral users, we have come back eventually to the point we've been discussing that we need to adopt a fact-sensitive approach in the discussion of whether there is independence or partiality or not. I think I'll just stop it at this point in time, Purnima.
Thank you very much, Kelvin. We've got a number of questions coming up. We have about 10 minutes left for questions. What I'll do is I will try and take 2 or 3 questions at the same time. And thank you, Kelvin, for trying and answering one of those in your 5 minutes. So, Shweta, if you could keep sending the questions and I will take them together. If the audience would like to type in any more, please do so while we answer these questions. Mr. Sibil, I was wondering if you would take one of the questions that have been set out here and I'll read it. Even in the case of panels, there are often scenarios where the party responsible for the constitution of the panel simply appoints its former employees' personnel. You've talked about this a little bit. Does this not impede the very principle of party autonomy and also the objective of appointment of an impartial arbitrator? Your thoughts on that? Mr. Sibil, you're on mute.
The courts have held that former employees do not fall foul of Schedule 7, as we've already discussed. And that's what creates the problem. So in many cases, panels have former employees. And it does detract from party autonomy in two respects, possibly. One is that, of course, the party has not really and genuinely agreed to this kind of arbitration clause in the first place, because it's a take it or leave it standard form contract in many cases. If you don't agree to the clause, don't take the contract. Secondly, even if you did agree to it voluntarily, the question is, if it is manifestly contrary to the principle of neutrality, then it's something that cannot be ignored. So since we've already discussed that this is a problem, the current legal position on it is relatively clear, that former employees are not precluded, and as long as that is mandated by the contract, if there is some involvement of the counterparty in the appointment of a multi-member tribunal, even with members of the panel who are former employees of the government entity, then the courts will not interfere. So this requires addressing. One way to address it is the way Anirudh suggested, that you widen Schedule 7. Another way to address it is that we need to have possibly a mandate to allow. The issue I want to touch upon is there is a reason why former employees have been allowed by the court so far, and Schedule 7 doesn't outlaw them. And the reason is there is some value in people experienced in that particular field having a role in the arbitration, and it obviously increases efficiency and so on. If that be the case, why can't you have employees of other similar organizations? Just don't have them of the organization that is party to the arbitration. And I think the aim should be not to eliminate former employees per se, but they shouldn't be former employees of that organization. And there's a plenty pool of officials who are retired or currently serving in other organizations who can be part of the arbitration. And the Law Commission suggested in its report that such people should enroll themselves in institutional organizations, which then can serve as a resource for appointment in these cases. Of course, none of this solves the immediate problem that these are the extant provisions in various contracts between government entities and private parties.
Thank you. Elodie, I have a question for you. In case of an ad hoc arbitration, if one party does not agree on the name suggested by the other, and a deadlock is created, what options are available? And I was wondering, Anirudh, if you could follow up after Elodie's comments, specifically what the options would be in the Indian context. Thank you.
Yes, so I mean, ideally, the parties, when drafting the arbitration agreement, would have provided, if there are no in and ad hoc arbitration, for the default appointing authority, so you don't find yourself in a deadlock situation. If that hasn't been done and there is no applicable, the UNCITRAL rules do not apply, so you're really without a defaulting appointing authority. One solution, which is not always realistic in practice, would be the parties at that time agreeing on a default appointing authority to break the deadlock. If the respondent is really uncooperative and is trying to stall the process, then I think you have to look at the Arbitration Act of the place of arbitration. Hopefully a place of arbitration has been provided for in the arbitration agreement. You look at the Arbitration Act, and usually you would be able to go to courts to get the appointment. That would be the state. But I mean, the advice is make sure in your arbitration, if you have ad hoc arbitration clause, your arbitration agreement provides for the default appointment authority so that you don't have a deadlock.
Okay, so in the Indian context, if there is, say there's an ad hoc arbitration providing for 3 arbitrators, one party appoints, the other does not, then the remedy is to file an application under section 11 for constitution of the tribunal. The same would apply in the case of an ad hoc arbitration where there's a sole arbitrator who is to be appointed and parties cannot agree upon the name. Even in such a scenario, you'll have to go under section 11. Recently, wide-scale amendments have been brought in, though not yet notified, because we are awaiting the accreditation of institutions. So now, under the new scheme, following the 2019 amendments, there will be an Arbitration Council of India that will accredit certain institutions. In such states where you have accredited institutions, the High Court will delegate the appointment to such institutions, and then you need not go to court, but you just need to go to such an institution. Yeah, so that's broadly the structure in place.
I think I've been told that we have very little time left. So Kelvin, quickly, if you have any thoughts on whether there should be 2 different legislations for any jurisdiction, one to deal with international commercial arbitration and one to deal with domestic arbitration, would that sort of address some of the issues that have come up during the course of this webinar?
Thanks, Purnima. I think that's actually a very largely policy question as to how the jurisdiction wants to develop its arbitration practice. I mean, in Singapore, we do have 2 different acts, one governing domestic and one governing international arbitration. But I'm not sure there's a distinction between the 2 when it comes to the question of independence and impartiality. Because when it comes to appointing the person who will decide the case, I find it hard to see why there should be a difference in principle and in approach as to what's a fair-minded standard of an educator should be in both cases. It should be the same standard. So while there could be good reasons to have 2 different regimes, but to the extent this question is directed at the topic under discussion, I'm inclined to the view that there should be a single standard, and perhaps to the extent that there could be some particular circumstances locally that could restrict the wholesale adoption of the practices under IBA guidelines, I suppose that could be solved when we approach it from the fact-sensitive approach that we've been discussing. Because if there is truly a lack of expertise that requires a different standard, then maybe that could be a reason in the context to consider that perhaps that could be allowable or not allowable, as the case may be.
Thank you. Mr. Sibil, there's a question specifically for you. Does the adoption of the IBA conflict rules in law impliedly restrict a court's ability to find disqualification beyond the IBA criteria? Your thoughts on that?
So there are 2 modes of challenge when there are justifiable doubts about the impartiality and independence of an arbitrator. One is the broader guidelines in Schedule 5, and that's where you have to challenge within 15 days of knowledge. And then the hard line rule in Schedule 7, which is a subset of the 5th schedule, where the arbitrator is rendered ineligible. As far as ineligibility is concerned, the courts have clearly held that they can't go beyond Schedule 7, and they apply it strictly. As far as Schedule 5 is concerned, it's the kind of thing that gives rise to justifiable doubts of independence and impartiality. I believe that there is greater play in the joints as far as a Schedule 5 challenge is concerned under Section 13 of the Act.
Thank you very much. So unfortunately, we can't take any more questions, but I think we've been with everybody for more than an hour. Thank you, everybody, for being patient and listening to us on a Saturday afternoon or evening. It's been a wonderful discussion, and I do hope that we do get the opportunity to continue these discussions beyond the webinar and someday in the real world. Thank you very much to all the panelists and to the SIAC for organizing this. I look forward to keeping in touch. Thank you, Kelvin, Anirudh, Elodie, Mr. Sibil, and Shweta. Thank you very much. Have a good evening.
Thank you.
Thank you.
Thank you, everyone.
Thank you, everybody.
Thank you.